My practice focuses primarily in representing people who are facing serious criminal offenses. I'm licensed to practice in state and federal court in Texas and New Mexico, and I'm admitted to practice before the United States Supreme Court. One of the key roles of a criminal defense lawyer is to keep your client from pleading guilty or being found guilty just because the government says you are. You need to have an attorney that can go in and look at the government's file, look at the evidence they have, and see whether, first of all, was it legally obtained? And if it was it properly stored or properly preserved? All of us have heard about DNA and how wonderful those examinations are, and the wrecks that they have with DNA examinations. Well, there's other kind of evidence that gets lost and misplaced and magically restored. We want to watch out for that too. You need to have a lawyer who can go in and look at your file and look at your circumstances, knows what you're trying to do, and then come back and give you his opinion of what the best approach for you to take is. I don't want you to be a railroader and just plead because you're scared. A lot of people ask, gosh, how can a lawyer represent somebody that they know is guilty? Well, guilt is only half of the equation. If your client's guilty, we need to work on punishment. We don't want to just let the government say, okay, you're guilty and see you later, bye. There's a wide variety of punishment options and ranges and different things that we can do to satisfy both you and the DA or the U.S. Attorney without having to be just pushed into it. You need to have an experienced lawyer who knows what those options are, knows what the ranges are, has a relationship with the government, and that he can work those things out. From years of practice, an experienced criminal lawyer has learned what things to do, what things not to do, and what approaches work best. There are times when you want to be calm and be subtle when you begin to approach a case. There are other times when you want to go in with more bluster and flamboyance and be more aggressive. Each case is different, and each person is different. And it's important to me to know all of that I can about you and your case. You don't develop that ability in law school. You don't learn it by sitting for the bar exam. And you don't learn it the first 5 or 10 years you've been practicing. My role as a criminal defense lawyer, first, is that I want to get to know you. I want you to come in and sit down across the desk from me. I'm not going to charge you for the first time you come in. I don't want you looking at your watch every 2 or 3 minutes saying, oh gosh, what's this guy going to charge me? I want you to be able to look across the desk at me, and I want to be able to look across the desk at you so that we can both get a feel for each other. There's a lot of things I can learn from talking to you face to face and in person that can't be developed on a telephone conversation. It's important for me to know those things that come from a face-to-face interview and develop a personal relationship with you so that I can go into the courtroom and speak with some conviction and earnestness when I'm trying to negotiate or persuade the prosecution or the government of our position. Give me a call. Let's set up an opportunity and a time where we can get together and meet so that I can help you or your loved one out.